G'day. Today I'm going to talk to you about the Tasmanian court system in detail. Here you see an overview of both the state laws and the federal laws, how they are administered by, first of all, the federal court system and the Tasmanian state court system. I'm going to start with the state system first up. There are three main layers. Let's go to the first one. The lowest layer, if you like, the lowest place in the court hierarchy is at the Magistrates section. That's where we hear summary offences when we're talking about criminal matters. Also, there's some indictable offences which normally get heard in the Supreme Court that can be tried summarily. That means just in front of the magistrate and without a jury. Criminal proceedings also held in the criminal division of the Magistrates Court, as there's also the children's courts and coroners courts and other specialist type courts which operate out of the Magistrates Court. Now we also have for civil cases, anything less than $5,000 where somebody has a matter that there's a dispute between one person and another. Then if it's up to $5,000 it goes to minor civil claims division. Anything above that, up to $50,000, gets heard in the Magistrates Court in the civil division. Therefore, by inference, civil cases above that get heard in the Supreme Court. The important thing to note about the Magistrates Court, that it's heard by the magistrate and he or she hands down the decision and the final sanction. There's no jury, and the court proceedings are a lot less simpler and a lot less expensive. For the more serious cases, we need to go to the next court, which is the Supreme Court. Let's look at that. Here it is. The Supreme Court is administered, heard by one judge. One judge administers that section. And we talk about indictable offences. So they're the more serious ones, like robbery, arson, rape, murder, those sort of things. They also hear appeals. They've got an appellate jurisdiction for the Magistrates Court and other administrative tribunals which sit in the state court hierarchy. It is with the more serious cases that we normally do have an avenue for appeal. There are usually two avenues, and the first avenue, which is still in the state sector, is to go up to the Court of Criminal Appeal. So by the nature of its name, that all the criminal cases go up there, and the civil cases, they go up to the full court of the Supreme Court. Note there's three judges that hear these matters. There obviously got to be grounds for appeal for it to be heard in the first place, but you've got more judges presiding over an appeal. So when it gets heard for the first time, it's one judge, and it's three judges in the next avenue of appeal. Now, if we go one step further, for the second appeal, if you like, we go to the High Court. They hear appeal from all courts in all of the states and the federal court, which I'm going to explain in a little moment. The High Court also hears constitutional matters. In terms of the appeals from the state Supreme Court, here you can see three judges are going to hear that case, and normally it's five judges in the High Court, sometimes more, but usually five. So the system is there to try and ensure that there's two avenues of appeal, that the decision that is finally handed down is the right one. So if there's a mistake or if there are wrong precedents applied, then they can be corrected in the appeal process that goes up to the higher courts. You can see also on this side, the family court and the federal court, the appeals in those federal courts, they also get heard in the High Court. Now let's go one step further. We're now talking about the federal side of things. So I've just looked at the state section, and here we are, we've got the federal system. Now, a bit similar to the state system, we've got a federal magistrates court where the less serious matters are heard, and you can see some examples here: some family law, administrative law, bankruptcy, consumer protection, migration, copyright, those sorts of things. So they're the less serious natured federal matters, which are obviously administered by federal laws. Then the more serious ones, they get heard in the federal court, so the federal state practices, legislation, and so on. You can see here also that the federal court hears appeals from Commonwealth tribunals, and I've got 3 such examples down here: administrative, the Social Security Appeals, Revenue Appeals Tribunal, to name but a few. There's quite a lot of those, but they get heard in the federal court. And as I mentioned earlier, that if there's the last avenue of appeal goes to the High Court. You can see here the family court, that's obviously relating to family matters, and those sorts of things. They get heard there in the first instance, and appeals in the second instance go up to the High Court. So once a decision is made in the High Court, they are binding on all other courts below. And that's an important thing to realise. So if we come back to the Tasmanian state court system, so a decision which is handed down, a precedent then applies to these levels here. If a decision is made in the Court of Criminal Appeal or the full Court of Supreme Court, then that is binding on the courts below. Now let's have a look at some of the advantages of having such a system, a court hierarchy as we call it. As I've mentioned already, that it allows the doctrine of precedent to operate. So if precedent set in the High Court, it then applies to the lower court. And the precedent's there to have a consistent set of decisions apply across the whole system. It allows for appeal system to operate, for appeals to be heard in higher courts, and I've already explained that. Courts can specialise in an area of law, so you've got the Magistrates court, they've got a lower range of matters. You've got the family law, you've got the federal court, and those sort of courts. They specialise in one area of law, which the decisions that are handed down are, I guess, more efficient, but also you've got proficient lawyers in those areas. There's fewer delays for less complicated matters like in the Magistrates court. The indictable offences, for example, that could get heard in the Supreme Court, they involve a jury, which takes a lot longer to set up, but also the evidence collected by the DPP, the Department of Public Prosecution, takes a lot longer. So if it's a simple case, it can be heard in the Magistrates court, and therefore it's a lot quicker. Generally, the more experienced judges hear the more complex cases, like in the Supreme Court and in the appeal courts, and then it's the really most experienced judges in all of Australia that sit on the High Court. Now let's look at the disadvantages. A precedent which is applicable, which should be applied, may not be necessarily applicable to a lower court, and therefore a incorrect decision can be made because precedents are binding on lower courts. They have to be followed. There may be lots and lots of appeals that some people may seem unnecessary, and therefore clog up the system and make it more expensive. And this also ties into the same point, that if you've got more courts, then we need obviously more money to administer those courts. And the people in the lower courts may not have the same level of expertise as in the higher courts. Alright, thanks for listening. I hope that's been informative for you. Of course, there's the text that you can refer to. The reason why I've made this video, this clip, is to make it more Tasmanian based, because the text that you use is Victorian, but there's a lot of information in the chapters in your textbook that is applicable, but the Tasmanian court system is different, as I've outlined to you. Thanks for listening.